A final judgment has not been made. A distinction must be made to the public, especially to our people of Wajir, of what it means to make a ruling and to make a judgment. A judgment entails the whole petition and the final decision of the court, while a ruling is an application that happens in between the due process of the court process. What our political competitors are saying out there in the field is that a final decision, a final judgment has been reached by the Supreme Court. There is nothing further from the truth. The actual truth is that an acceptance was given to the appellants to introduce the new evidence that they have.
At the second level of appeal, new evidence is taken. But the court, I'm not a lawyer, the court has argued that it has the jurisdiction to do that. We would want that expedited because it's a retrial of the facts in a sense, which were tried at the first court. So all we want to ask the Supreme Court is, can we do it fast enough? Can we allow this guy to adduce whatever new evidence he has? And can we be allowed to interrogate the same? And also, can we be allowed to bring further evidence to prove that indeed he doesn't have a degree? Because we also have a lot more further evidence to prove that he does not have a degree.
The due process will take place. It was a ruling that we least expected. We already had issues with the Supreme Court on the protracted time the case has been taken. 5 months down the line, this was the first ruling. We are yet to reach the most substantive hearing of the petition. Equally important to note to our supporters and the larger people of Wajir County is that the election was nullified based on 9 grounds, 8 of which were election malpractice and 1 was on academic ground. The question of the academic ground isn't yet settled. The court gave an opportunity, a new lease of life to the appellants to adduce more evidence. Whether that will eventually be accepted or otherwise will depend on the eventual hearing and determination by the judgment, by the bench. We are telling our public, therefore, specifically to our people of Wajir, that today's case was a ruling. It was not a final judgment. That judgment will come. We will also have our own share of evidence to prove otherwise. Hearing will be made and timelines will be effected.
Usual for a case to stay in the Supreme Court, a petition case for that matter, for 5 months without anything moving. This was the first case to have gone there. The Court of Appeal decision came on 20th of April, and there was already a lot of hue and cry about this inordinate delay by the Supreme Court on this matter. We see that this is going to take a little bit more time, but the court has made its decision. So what we're saying is, can that be done quickly enough? Can that new evidence be brought, and can we be allowed to interrogate it?
One thing is for sure, and we need to assure to our public, to our supporters there in Wajir, that by-election is a foregone conclusion. What we are deciding on now here is whether someone will contest or otherwise. That will be decided later on. So we are here to tell you, don't listen to the rumors outside there. There's a lot of shenanigans outside there, that a final judgment has been reached. No. A difference and a distinction must be made between a ruling and a judgment.
Public has been deceived that this seat was annulled on the basis of the incumbent governor's qualification only. That's not true. There were 9 grounds, 8 of which were electoral fraud and malpractices. So we'll also want to see how that plays out in court, because the new evidence being adduced here is on the degree. What of the other 8 grounds on which this seat was nullified. But whichever way it goes, I think what is important is for the Supreme Court to expedite this so that the county does not continue being in limbo, and so that hopefully we get back to elections sooner than